Hello, welcome to this webinar. What we're going to be looking at today is the current state of the law as regards capacity for will writing, with a look at some of the recent cases and some consideration of the sort of issues that we as practitioners need to think about when we're drafting a will. So to some extent, what we've got is a rapidly changing situation. What I'm trying to do is to bring this as far up to date as I can and see where that takes us. But bear in mind that this is a constantly changing situation. On the first slide, what I've done is to list the various topics that I want to try and cover today. The first of those is, when does the testator need capacity? What I'm interested in there is issues where the testator's got fluctuating capacity, or where capacity disappears or becomes less sound between the giving of instructions and the execution of the will. So that's my first issue. I want to have a look at what capacity is, and one of the things that I'm going to mention along the way there is affective disorders, things like drugs, drink, alcohol, not mental capacity as such, but the sort of outside factors that may affect capacity temporarily or permanently. Want to look at how the test is, how capacity is tested, and that's where recent case law comes in, because this is, as I say, is an ongoing situation. When we've done that, I want to talk about the golden rule, insofar as that is still relevant, and how that will affect your practice. And I also want to pick up fairly briefly on the relationship between capacity and knowledge and approval of contents and undue influence. I don't want to spend too long on those two topics, because that's a separate course in itself, but I do want to make some reference to that as we go along. And there are some practical issues that will come up intermittently and right at the end. So the first issue I want to tackle, the slide refers to the rule in Parker and Felgate. Now, this is